The detective leans forward. His hands are folded on the table. Look, we already know what happened. Your buddy told us everything. We just need to hear your side. If you ever hear those exact words in an interrogation room, you are being lied to. And what you say in the next 60 seconds will decide whether you walk out free or spend the next decade in a cell. This is the oldest deception in the Reid Technique playbook, and it works 73% of the time. Here's why it works, and more importantly, here's how you beat it. First, understand this. Police are legally allowed to lie to you during interrogations. Frazier versus Cupp, 1969. The Supreme Court ruled that deceptive tactics do not violate your constitutional rights. They can't lie about whether you're under arrest. They can't lie about your Miranda rights. But everything else? Evidence, witnesses, confessions from co-defendants, forensic results, all of it can be completely fabricated. The phrase, "we already know," is psychological warfare disguised as casual conversation. It does three things simultaneously. 1. It creates false inevitability. You think the case is already closed, so why keep denying it? 2. It weaponizes isolation. Everyone you know supposedly betrayed you. 3. It makes lying seem futile. If they already have the truth, why not just explain your version? Your brain begins a catastrophic calculation. If they already know, maybe cooperation will help me. That thought is exactly what they're engineering. Columbus, Ohio, March 2019. 2 detectives interrogate a 24-year-old man suspected of robbing a convenience store at gunpoint. No weapon recovered, no surveillance footage showing his face, no physical evidence. The detective opens a manila folder, doesn't let the suspect see inside. Your boy Marcus already told us everything, said you had the gun. We know you were there. We just need to understand why it happened. Here's the problem. Marcus was never arrested, never questioned, never mentioned the suspect's name. The entire statement was fiction, but the suspect didn't know that. He thought his friend had betrayed him. He thought the case was already built. He thought honesty might create leniency. So he started explaining. I was near the store that night, but I wasn't inside. I didn't even know Marcus was going in there. He just placed himself at the scene of a crime. Before that sentence, the detectives had nothing but a vague description from a traumatized clerk. After that sentence, they had a suspect who admitted being present. 6 follow-up questions later, they had timeline inconsistencies. 12 questions after that, they had a full confession. The folder the detective held, it was empty. San Diego, October 2016. Federal agents interrogate a 31-year-old woman suspected of wire fraud involving client funds. The lead agent slides a folder across the table. We've already pulled your bank records. We know about the transfers between accounts. We've seen the timestamps. We just need you to walk us through your reasoning. She believed them, so she walked them through it. Every transaction, every decision, every amount. I moved the funds temporarily because the client account had a processing delay. I was going to move it back. She thought she was explaining innocent intent. She was actually providing probable cause. Because here's what she didn't know. They hadn't pulled any bank records. They had no warrant, no subpoena, no financial documentation whatsoever. They had a suspicious activity report from her bank. That's it. Her confession became the evidence they used to get the warrant. She built the entire case for them. By the time her lawyer arrived, the damage was permanent. This tactic exploits something called social proof theory. When authority figures claim that others have already confirmed information, your brain makes instant assumptions. 1. If multiple people said it, it must be true. 2. If I'm the only one denying it, I must look guilty. 3. If everyone else cooperated, maybe cooperation is the smart move. All 3 assumptions are strategically implanted. Here's what defense attorneys know that most people don't. Innocent people talk themselves into convictions far more often than guilty people do. Guilty people expect deception. They understand the interrogation is adversarial. They lawyer up immediately. Innocent people think the truth will protect them. They think, I didn't do anything wrong, so talking can't hurt me. That belief destroys lives. Because in an interrogation room, the truth isn't your shield. It's their raw material. Every detail you provide gives them something to verify, cross-reference, or contradict. Every explanation creates an opening for follow-up questions. Every timeline you establish becomes a trap if you misremember a single detail later. You are not having a conversation, you are providing evidence. So what do you actually do when a detective says we already know? You say 5 words, nothing more, nothing less. I want a lawyer now. Not, I think I might need a lawyer. Not, should I have a lawyer for this? Not, can I call someone first? I want a lawyer now. The moment you say those words, the interrogation must stop. Miranda versus Arizona, 1966. Davis versus United States, 1994. Edwards versus Arizona, 1981. Once you invoke your right to counsel, all questioning must immediately cease. They cannot ask follow-up questions. They cannot say just one more thing. They cannot ask you to clarify whether you really want a lawyer. If they continue questioning after invocation, anything you say gets suppressed at trial. People worry that asking for a lawyer makes them look guilty. It doesn't. Legally, it can't. Griffin versus California, 1965. Prosecutors cannot comment on your exercise of Fifth Amendment rights. The jury will never hear he asked for a lawyer, so he must be guilty. What they will hear is your confession, if you gave one. Here's what detectives will never tell you. If they actually had the evidence they claim, they wouldn't be in that room with you. They would simply charge you. The fact that they need your words means their case has gaps. Gaps they need you to fill. When a detective says, "We already know," what they're really saying is, "We don't have enough, and we need you to give it to us." It's a bluff, and the only way to win against a bluff is to refuse to play. You don't owe them an explanation. You don't owe them your cooperation. You don't owe them anything except 5 words. "I want a lawyer now." Then you stop talking. Not because you're guilty, because you're protected. Not because you're hiding something, because you understand the game. The interrogation room is not a place where truth sets you free. It's a place where words become evidence. Protect yourself. Use your rights. Say 5 words, then say nothing else. "I want a lawyer now." Say nothing else.